Okay, so this week we're looking at the theft chapter in your book. By Missouri state statute, though, we're going to call this stealing. And when we go to chapter 570, one of the things that you're going to notice with it, a very large chapter that deals with several different crimes as far as property related. Obviously, robbery is going to be in there, stealing, when we start looking at those. But different things that we may not think of, like theft of cable television, feigned blindness, lost property, claim of right, and when those become actually criminal offenses. In Missouri, when we start looking at lost property, a person who appropriates lost property shall not be deemed to have stolen the property within the meaning of 570030, which is the statute number for stealing, unless such property is found under circumstances which gave the finder knowledge of or a means of inquiry into the true owner. So let's say that you find a garden hose on the side of the road. Nobody's name's on it, something like that. Based off this statute, if there was no way to figure out who the owner was and you picked that up, you wouldn't necessarily be guilty of stealing. The other crimes in here that we're going to talk about and are talked about in your book: crime of passing a bad check, fraudulently stopping payment on an instrument. All of these different ones, check kiting, identity theft, trafficking, would be consistent with our stealing chapter. And then it goes down as far as status for the state of Missouri. Unlawful receipt of public assistance, and then even breaks those down. Mortgage fraud, misuse of military medals falls under our Missouri statute as far as those crimes against property. Some vocabulary this week that I really want you to pay attention to. One of the words here is appropriate: to take, obtain, transfer, conceal, retain, or dispose. So when we're talking about somebody taking property and they appropriated it, it can be any one of these things. Sometimes we get very narrow in our scope as far as looking at what stealing actually means. And we, again, like I've said before in many of the other chapters, you have to know what your vocabulary is in order to make those good cases. So conceals, retain, or dispose of. So somebody takes something and they just hide it. They don't really have it. That falls under that definition of appropriate. What a check is, or what a credit device is. I remember when debit cards first came out, and did we consider that a credit device was a question that we asked. A dealer, a debit device, writing a card number or other device other than a check. So deceit or deceive, what does that mean as far as our statutes going? And that's just representing, which is false. How to deprive, to withhold property of the owner permanently, to restore property only upon payment of reward. To use or dispose of property in a manner that makes recovery of the property by the owner unlikely. This is an interesting one in here, that to restore property only upon payment of reward or other compensation. You find something, you know who the owner is, and you make a demand that says, hey, I'll give it back if. And there's where somebody can get themselves into some trouble. Forcibly steals, internet service, means of identification. All of these, what they are. For our chapter this week, property is anything of value, whether real or personal. Real is usually going to be real estate. Tangible or intangible, in possession of or in action, and shall include but not limited to the evidence of debt actually executed but not delivered. So property is pretty specific as far as what it is. And then public assistance, services, stealing related offenses. There's where it's going into federal and state violations. Video service, voice over internet protocol, having to do with the phone service. And then what is a writing? So when your statute starts talking about a writing, this is what it's talking about. Like I said, I put it in your lecture this week. Know what appropriate, coercion, credit device, debit device, deceit, forcibly steals, property, and writing. So vocabulary: larceny, theft, and for our state, stealing. Stealing property of another with the intent to deprive. Taking, the act of obtaining physical possession of control of another's property. So this is the actual theft. Fraud, embezzlement, to wrongfully appropriate money or property entrusted to one for their own purpose. So you work for a company and you start using their property for your own benefit, or you just don't return the property. Shoplifting. Probable cause. This one is important in that probable cause, depending on which definition you use, is generally facts and circumstances that would lead a reasonable person to believe, crime's been committed by a specific person. Where we start looking at probable cause here is that definition can also mean reasonable grounds depending on what state statute you're looking at. Defamation, injuring the character or reputation of another by oral or written communication. Forgery, wrongfully signing a writing or instrument in the name of the person who issued it. So uttering, putting into circulation a check known to be worthless. Check kiting, creating multiple checking accounts at multiple banks for the purpose of writing fraudulent checks, and that actually is in our statute. So what if scenario? What if you take your car to a local automotive repair shop and have work done, but don't have the money to pay for it? What right does the repair shop have? And in Missouri, it's called a mechanic's lien when we start looking at that. And basically, they can hold that vehicle, and they have the legal right to do that. I provided that link there because this is a question that sometimes will get asked, that, hey, they won't give my property back. Well, did you hire them to do something? Would be your next question. And if that's the case, then the person that's done the repairs can actually do a mechanic's lien on that property. So general property concepts. Property is divided into two types, real or personal. You need to remember that. Any property can be stolen, including tangible personal property or an intangible, such as writing like stock certificates, electricity, cable television, different things like that as far as electronics can be stolen based off our statutes. So in almost all situations, a thief cannot convey lawful title to stolen property to another, even if that person is innocent, good faith purchaser. So somebody is, selling a stolen property, and you make the mistake of buying it. That buyer beware situation, which in Latin would be caveat emptor. But at the same time, they can't legally sell that property. Movable property, person guilty of theft, they take or exercise unlawful control over movable property, something that we can actually put our hands on. And then immovable property. So let's say somebody forges a deed or something by deceit and tries to sell property that they don't have a legal right to sell. So two important rights of property, the right of ownership and the right of possession. So property ownership may be in the form of sole ownership, joint ownership, or vested in a government unit. So say our state parks would be a government unit. Single ownership, pretty self-explanatory. Joint ownership may be, two individuals in a business, a married couple. Lawful possession of property takes many forms. So a thief has neither the lawful right to possess nor ownership of stolen property. Where we can get confusing is the money rule is one exception, in that no one gives what they don't have. It provides that a person who receives money in good faith and for the value given takes title to the money. So money is one of those complicated ones that we run into when it comes to stealing cases. So theft, larceny, stealing, like I said, all of these basically mean exactly the same thing. So elements of stealing, taking, so the actual carrying away or getting possession of it, property of another with intent to deprive the other or owner of possession. So 570030 is the stealing statute, and you're going to be expected to know this statute. The first thing you're going to notice about our stealing statute of 570030 is it's rather long, but there's only one of them, and it covers felony and misdemeanor as far as stealing goes. So a person commits the offense of stealing if he or she appropriates property or service of another with the purpose to deprive him or thereof, either without his or her consent or by means of deceit or coercion. So as far as your vocabulary words, in one we have appropriate, we have deceit, we have coercion. So we have a lot of those words that we need to understand what they actually mean as we read that statute. And then it breaks it down into, this would be a Class A felony. This is going to be a Class B felony. The reason that we put anhydrous ammonia and liquid nitrogen in is these are used in the manufacture of certain illegal drugs. The property consists of any animal considered to be livestock. You need to understand what livestock actually means, and so they've provided a definition. Or any captive wildlife. Here is our definition as far as what livestock actually would be. Cattle, calves, sheep, swine, emus, ostriches are specifically named in there. Aquatic products, so somebody stealing fish. Alpaca, buffalo, bison, elk, as far as that. Goats, horses, other equine, honeybees, and or rabbits for human consumption would all be considered livestock when we start looking at that stealing statute. So as we work our way through, it's going lower as far as the class of crime. So a Class C felony, if the property appropriated is $25,000 or more. The offense is a Class D. The value of the property is $750 or more. So again, as the value of the property is less, then the crime is less. Now, one of the things that we look at though is how much is a rabbit actually worth. It's not worth $750, but it would still be a higher class felony based on the statute. So we go further. Aircraft, real property, we understand now that that's real estate. Letter of credit, any firearm, any explosive, theft of any credit device is going to fall under that felony range. Any book of registration, any live fish, a captive animal held with a permit, any controlled substance. And this doesn't matter if it's a legally or illegal substance. So somebody goes in and steals, methamphetamine from somebody else. We know that it's illegal to possess methamphetamine in most circumstances. And we could still charge the thief with stealing. So ammonium nitrate, this is fertilizer. This is what was used to make the Oklahoma City bomb. Any wire electronic transfer, metallic wire associated with transmitting. This is where people were stealing certain cable and different things like that. Any material appropriate with intent to use to manufacture amphetamines or methamphetamines. It's a Class E felony, so the lowest class or property is an animal. So it's any animal is going to be a Class E felony. Livestock would be a little bit higher. A person has previously been found guilty of 3 related stealing charges, so they were looking for that prior offender. Offense is a D misdemeanor. Property is not the type listed in sections 2, 3, or 5, or 6 of this section, and it has a value of less than $150. Now, years ago when I first started, $150 was the start of the felony range. Stealing statutes do change based on what the value of property is. Class A misdemeanor if no other penalty is specified in this section. So it breaks it down, and you're going to want to look through those stealing statutes. So in all states, the value of property determines the severity of offense. We just looked at that. We do not have a grand larceny in Missouri. All of it falls under stealing. So theft can occur until the defendant has theft cannot occur until the defendant has in some sense taken the property. Pickpocket has not stolen the contents of your pocket while his hand is still in your pocket. Now, if you remember back from the inchoate offenses, we do have an attempt. So if we caught that person at that moment, we could go ahead and arrest them for attempted stealing and or charge them. Under common law, carrying away requirement help determine when a taking was complete. So when that person was able to exercise dominion over the property and actually move it or put it somewhere where the owner couldn't, have access to it. In most statutory schemes, taking is complete when the defendant has exercised, again, that dominion or control. Switching bag tags, so airline will deliver another bag to you is sufficient exercise. So you bring a suitcase with junk onto an airline, but it looks like other suitcases, and you just switch the tags so that you pick that up, and then you can steal what is in somebody else's bag. You leave your lawnmower in your backyard and your neighbor comes over to borrow it. When you are not home, he takes the mower but forgets to return it. When you know it's gone, you call the police and report it stolen. Has your mower been stolen. What we would look at here is, does your neighbor normally borrow your lawnmower, or would they think that they could borrow their lawnmower? If you call them and they say, oh yeah, I've got it, I'm sorry, and they immediately bring it back, we probably don't have a theft. If they say, yes, I borrowed it, and you're not getting it back, that's when we would have that theft. So property of another, again, it must belong to another. A leaves property for B on the safekeeping. C steals the property from B. Though not owned by B, it is property of another. So one that somebody asks you to watch something for them while they're gone on a trip, and somebody steals that something, you could actually file the charges because you were in charge of that property at that moment. Think about a store. Those individual items sold at our local big box stores, the people that are, working the registers, that are the managers, that are loss prevention, they don't actually own that property, but they can still file that charge. Co-owners can steal from each other. One thief can steal from another. So that's an interesting situation when you can run into it. You do have to have the intent to steal, just like we talked about the lawnmower, whatever that culpable mental state is at that moment. One who accidentally takes another's property cannot be a thief. So A takes what he believes to be an empty box home from work. In fact, B has stored some goods there. They're not guilty of that theft. You go to a restaurant where coats are hung up, and you accidentally take someone else's coat that looks just like yours. You don't even realize that you've got the wrong coat. You have not stolen anything. So in most states, intent must be to deprive permanently or for an extended period of time. So borrowing something would be a defense. And if the defendant can prove that, they just borrowed it, or they would normally feel like they've had permission to use it, they wouldn't be guilty. One of the scenarios that you may run into, depending on which branch of criminal justice you go into, is you get a call from a parent that says, my child has stolen the car. You get there, the parent and child have had an argument. Child is a legal driver. They normally drive that car. In most instances, they probably haven't stolen it. When you ask them, do they normally drive the car? Well, yeah, that's the one they drive to work. That's the one they drive to school. But today, I don't want them to use it. Well, you probably are not looking at a stealing case. For most of those cases, I would suggest that you get a hold of the kid and say, hey, your parents want the car home. Now, if they refuse to bring the car back or hide the car, it could turn into a stealing case, but at that very moment, you probably haven't got anything that's actually stealing. So if your girlfriend puts her furniture on the front lawn while she's having her carpets shampooed, and somebody comes by, picks it up. The furniture is found by the police, and the men who took the furniture claim that they thought it was abandoned. Was it abandoned? And so we have to look at the RSMO to figure out what abandoned actually means. So what we would do is we would go to ownership and conveyance of property. So that's chapter 447 if we're looking at RSMO. And the duty of a person finding lost money or goods. And what the law says as far as our state is that any person finds any money, goods, right in action, or other personal property or value, thing whatsoever of value, of $10 or more, the owner of which is unknown, he shall within 10 days make an affidavit before some judge of the circuit court of the county, other than a municipal judge, stating when and where he found the same, and that the owner is unknown to him, and that he is not secreted, so he's not hidden, withheld, or disposed of any part of it. So it's saying that if you find something, you need to let somebody know if the value is $10 or more. And then appointment of appraiser, and looking through this statute, start figuring out how and when a theft would occur, or if the property was lost or abandoned, then how they were going to go about that. You could get a call that some property was stolen. Somebody may not even realize that they were in possession of that stolen property. They bought something at a sale or something like that, not knowing it was stolen. Somebody else says, hey, that's my property. And they're like, no, it's not here. I have a receipt. And you have to work that out of who had knowledge as far as where that property belongs and then who it belongs to. So shoplifting, we're all very familiar with this. Difficult in fitting retail shopping within the taking language, because what it is you're walking around a store and you're shopping. Now normally you're going to carry that in your hands. Common sense says you probably shouldn't be hiding this under your clothing, but you hide it all under your clothing and you walk up and you pay for it. Have you shoplifted? That depends on who's looking at it and what they can show as far as intent. So shoplifting statutes commonly describe the crime as the intent to appropriate merchandise without paying or deprive the owner. Again, all of our shoplifting would fall under stealing. Don't go looking for an RSMO that says shoplifting. You're not going to find it. You will find 570030, which is your stealing statute. Detention of the suspect by store personnel. This is state by state, and we're going to look at this here in just a second. But this right here, I've provided a link for you. An attorney talking about when shoplifting is shoplifting and when it's not. Now, this person is advertising for somebody that's been charged with stealing, but it's very interesting to watch that video, so I would suggest you follow that link. So shoplifting statutes, most statutes list specific actions. Concealing merchandise while in the store. There's no need to leave the store. A lot of people are confused by this, and most store loss prevention are told, hey, don't do anything until they leave the store. That's a policy, not necessarily the criminal statute. If you're in the store, you conceal the property on or about your person, and you could actually look at that as far as law enforcement, and your prosecutor's office has a theft occurred. Altering or changing price tags. This was a case that we dealt with several years ago, that people would go in and they had a small printer that could print UPC codes. So they would scan something of a much lower price but of a similar nature. So let's say they scanned the price of a small television, printed a new UPC code, stuck that on a higher price television, and they would walk that through the line and they would pay that price. So they were altering or changing price tags. Moving goods from one container to another, causing the cash register to record an incorrect price. So shoplifting store may be stopped and questioned. And here is our statute on detention of a suspect by store personnel. Some of you may work loss prevention, and so the policy of the store may be actually different than this statute. So we start looking at our statute. Remember, 570030 is the stealing statute, but this falls under 537.125, shoplifting, detention of a suspect by a merchant. So mercantile establishment gives a definition of that. What is merchandise? What is a merchant? And then wrongful taking includes stealing of merchandise or money or any other wrongful appropriation of merchandise or money. Remember, you have to know what appropriate means. Any merchant, his agent, or employee has reasonable grounds. So we talked, the difference between reasonable grounds or probable cause to believe that a person has committed or is committing wrongful taking of merchandise from a mercantile establishment, may detain such a person in a reasonable manner for a reasonable length of time for the purpose of investigation. So this is the statute that protects those. But again, everything must be reasonable. Any person who willfully concealing unpurchased merchandise of any mercantile establishment, either on the premises or outside the premises, shall be presumed to have concealed such merchandise with intention of committing a wrongful taking. So there's our taking that we started looking at. So, this is prima facie, or at first sight when we start looking at this, is when they start concealing it. That's when we start looking at that stealing statute. So this will be one that you will want to read, especially if you're thinking about going into loss prevention, asset protection. So tag switching, a lower price is placed on the store item. Undercharging, so this is where a clerk's friends go through and they don't charge them the full price. Storming, so a group of people go in and they just hit the store all at once. Till tapping, reaching into the cash register. Boosting, organized form of shoplifting used by gangs, large quantities. They will have, bags that they'll line, similar to what's called a Faraday bag, which blocks the electronic transfer of information and it won't set the alarms off when they go out the store. Credit card theft occurs when a credit card is stolen. Every state has a statute, and we looked at ours. The method of obtaining credit cards for fraud use can be many, just depends on the sophistication of the person actually doing that theft. Credit card itself doesn't have to be stolen. If somebody can get a hold of the numbers and then the codes that go with that, they can still be charged with that theft. So check violations, bad check. Not as big a deal as it used to be, just because checks now are electronically deposited. In fact, a lot of retailers don't even keep your check. They just run it through on your routing and account number, and they treat it just like a debit card. So forgery, under our statute, we have to look at, a person commits the offense of forgery with the purpose to defraud. That person makes, completes, alters, or authenticates any writing so that it purports to have been made by another person. So any writing, as far as that goes, erases, obliterates, or destroys any writing. So let's say that they're taking off the serial numbers of certain items, makes or alters any other thing other than a writing. So they could make something that they say, this company made it, but in fact it was not. That could still be considered a forgery. Universal product codes, antiquity, rarity, ownership, or authorship. So they're sports memorabilia. They're saying it came from a certain player that would be, the value would be very high. In fact, they just made it themselves. That would be our forgery statute. A very good statute to use as far as criminal investigation goes. When we look at uttering, as far as, passing a bad check, we don't use that specific term, but we do say that with the purpose of defraud, they make, issue, or passes a check or other similar side order in the form of presentation. So this is what we start looking at as far as uttering. So when they present that bad check or whatever they're trying to exchange that's not good, that's when we say that the uttering actually occurs. So again, our passing bad check statute is right here. And again, it's fairly lengthy, but you'll want to look through that. Check forging rings. One of the more interesting ones that I had seen several years ago is people would go into rather large construction companies and stuff like that. They would draw the attention of whoever was in an office, and another person would go in there and try to find the checkbook. And these are usually rather large, and they would take 2 or 3 pages, several layers down in those checks. And then they would write the checks to fake employees, and then they would go cash that check. Well, the company wouldn't really know it until later on when they started managing their checkbook and figuring out where that money went. And these groups would hit, and maybe 10 people all go out and cash a check under a certain amount so it wouldn't flag with the bank. And they would go in and have the check stolen and cashed within a day, and then they would move on to the next area. Again, uttering, putting in a circulation check known to be worthless. This could also be counterfeit money. So, depending on what your statute is as far as counterfeiting. Committed with a forged check with a bad check that's not forged but is known to be worthless. So somebody doesn't have the money in their account, they can do the same thing. Raised bills, so you got a dollar bill and you switch it to a $100 bill, depending on how you do that. There's a term I call bleaching, where money is bleached out and reprinted. So forgery, like we looked at with our statute, written instruments or documents, checks, or government bonds that we know are not correct. Now remember, our forgery also covers anything not considered to be a writing. Makes an instrument, completes an instrument, endorses an instrument, alters an instrument, changes a 10 to 100 on a check, utters an instrument, so they present it to the bank. So check kiting, like we looked at the very first of this lecture, that falls under our statute. So this is where somebody takes a check, deposits it in an account, opens an account, they go get another account, they write a bigger check and deposit it in there, and they just go back and forth between banks. Now, used to, you had to wait so many days for a check to clear another bank. Now with electronic transfers, this is a much harder crime to actually do this. So here are some other statutes that I've just put in here that deal with property, attachments, bonds, some different things that you may be interested in. Landlord-tenant actions is something that we get involved in when we start looking at property and has something been stolen or not. But those are in there. And so that is it for our stealing statute. Remember to read Chapter 9 and then follow the links I provided in this lecture. That way that you can get a little more knowledgeable as far as what is a theft and what actually isn't.